Meeting generally supposed to be 8. Or no, second, third. In May. For planning, I used to go down here. So once they do, it's 9:13. So we may see some of this.
Hello, it's Brian. Brian's calling in.
Very good. All right. Supervisors, please join me in reciting the Pledge of Allegiance. And stands one nation under God, indivisible, with liberty and justice for all. Members present include myself, Chairman Jacob Pride, Vice Chair Robert Lovenheim, Supervisor Brian Barrett via Zoom, our Township Manager Julia Helica, our Engineer John Tressler, and Solicitor Ron Karasek, as well as many members of the public. In terms of announcements, we have a couple. There was an executive session on March 27th from 6:08 p.m. to 6:25 p.m. regarding Shriver litigation. Spring leaf pickup in Smithfield Township is April 17th through April 28th during our regular business days. There's some information about township roads and whatnot on our website. We received a grant from the Pocono Mountain Visitors Bureau for tree removal at Menacing Park for those that are affected by the ash borer beetle for $10,005. And we received a statewide LSA grant for Marshall's Falls Park Phase 2 for $367,500. Those are announcements. Next, we have to consider 2 sets of minutes from the March 22nd and March 27th regular and special business meetings, respectively. Have my colleagues had a chance to review those sets of minutes?
I reviewed and I'll make a motion to approve both.
Motion by Mr. Levinheim, do I hear a second?
Yes, you do.
All in favor?
Aye.
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 And next, we have our public hearing this evening, which is the Shawnee conditional use application for the addition of property to the inn. Before we get into the formal aspects of the public hearing, I'm going to turn it over to our Solicitor Ron Karasek, who can go over some preliminary housekeeping matters to practice the formal proceeding for us. Everyone that wants to speak will get their chance to speak. At this point, Solicitor Karasek, the floor is yours.
Thank you. Good evening, everyone. My name is Ron Karasek, and I am Township Solicitor. And it's my render legal advice to the Board of Supervisors, who will be hearing tonight's proceedings. They sit sort of as judges, if you will, to examine exhibits, listen to testimony, and render a decision on the application. Before we begin the formal hearing, there are some housekeeping and procedural items that we should review. First of all, a conditional use is a certain use to be granted or denied by the Township Board of Supervisors pursuant to express standards or criteria as set forth in the zoning ordinance. Those conditional use standards in our particular case can be found in the Township Code of Ordinances, Chapter 27, Section 705, and the subsections thereunder. A conditional use is similar to a special exception use that is granted by the zoning hearing board. In fact, many of the legal standards of a conditional use and a special exception use are the same. The major difference is that a special exception use is decided by appointed individuals, those who are appointed to the zoning hearing board. However, a conditional use is considered so important that that decision needs to be made by the elected officials, not just appointed individuals. In these conditional use proceedings, there's a shifting burden of proof. The applicant has to persuade the township that the use is in fact permitted and that the use meets all of the ordinance requirements. Once the applicant does this, then the presumption arises that the proposed use is consistent with the general welfare and should be approved. Then at that point, the burden of proof shifts to any objectors to rebut that presumption by proving to a high degree of probability that the use adversely affects the public welfare in a way not normally expected from that type of use. Further, a township is free to reject any testimony it wishes, even expert testimony. Now, this particular project is, I'm going to give you just a brief snippet, and then it will be presented more fully by the applicant and its representatives. This project is being filed on behalf of the Shawnee Inn and Golf Course Resort to incorporate 133 Worthington Avenue, Shawnee on the Delaware as part of the Shawnee Resort. The property is currently owned by Shawnee Investments and will be leased to Shawnee Inn and Golf Course. There are no plans for any changes in ownership and no development is contemplated. The property is currently improved with 3 buildings, one with a basement, 3 bedrooms, living area, and kitchen, with a porch on the back and front of the home. The other building is a rental property consisting of 2 units with 2 bedrooms, a living area, a kitchen with storage areas below each unit, and garage facilities meant to rent to occupants of 31 days or more. Property is located in the R-1, which is the low density residential district. And a resort use is allowed in that district as a conditional use. The property is contiguous and across the street from the property that's owned by the Shawnee Resort. And has been purportedly operating as a resort use before zoning regulations were adopted. The contemplated use is for guests of the Shawnee Resort or employee housing. If the project is approved, the Board of Supervisors can attach reasonable safeguards and conditions to the use as would be necessary to implement the purposes of the State Planning Act and the zoning ordinance. Now, this is a public hearing. It's a little different than a public meeting. A public meeting is to discuss township business at a meeting open to the public and if necessary, take official action at that meeting. Public hearing is somewhat different in that while it is still a formal meeting, its purpose is to inform the public of a potential project and obtain public comment prior to the township taking official action. The parties and witnesses to such a hearing have to testify under oath, although the formal rules of evidence don't necessarily apply, although immaterial, irrelevant, and non-probative evidence can be excluded. Now, let me just talk about one other item, and that's a difference between a party to the proceedings versus a public commentator. Party, as opposed to a mere public commentator who offers comment either for or against the project, has a direct, substantial, and immediate interest in the proceedings, which is more than the general interest that would be common to all township citizens, township taxpayers, and the like. For example, a party could argue that it is an adjoining property owner whose use to his or her property would be affected by the project, whether it be for traffic or lighting or other such issues. If any person here wants to claim party status and the applicant objects, the township will allow the applicants or their agent or attorney to ask questions regarding that party status so the Board of Supervisors can make a determination as to whether or not to grant party status. If party status is given, that individual is able to question witnesses and introduce evidence on his or her own behalf. But as a party, that person is now also subject to cross-examination by the other parties, by the attorneys, or anyone else interested in this matter. So if anyone wants to appear as a party, at the time I ask, I'm going to ask you to come up to the dais here and sign a sheet noting your name and address so we know where to contact you as this matter would proceed. So. That being said, anyone who wishes to speak rather than as a party will be considered a public commentator. Note that there is law under the PA Open Meetings Act to support the proposition that only township residents or township taxpayers are entitled to offer public comment. However, it has been my experience at Smithfield Township, in the interest of promoting governmental transparency and responsiveness, generally accept public comment from anyone that is not abusing the privilege. Finally, you should know that the Township Planning Commission has reviewed this conditional use application and is recommending that the use be granted with the condition that the use complies with all building code requirements for a resort use.
Ron, what was that? The condition was what?
That the use complies with all building code requirements for a resort use. All right, so that being said, does anyone here want to be a party to this proceeding? Yes, okay.
There's more than just me.
Okay, well, you have to tell us why you want to be a party so the board can determine whether or not to give you party status.
I live at 171 Minnesink Avenue, on one lot away from the property in question. My name is Robert Holland.
Robert,
And I am opposed to any zoning changes made in our village. And I don't see where it would be beneficial to our community.
okay, we're not there yet. All I need is your name and why you believe you have party status.
Well, I just told you why. My name's Robert Holland,
Holland,
Holland, 171 Minnesink Avenue,
and you're one block away,
one lot away.
one lot away. Okay. All right, based upon what I'm hearing there, Board, I would recommend that Mr. Holland be given party status based upon his proximity to the project.
I have no objection to that.
Brian, did you hear that?
Yes, I did. No objection.
Okay, so we will then note that Mr. Holland has party status. All right, then I believe that Ms. Leachy had her hand up, so
Yes, I did. By default, I believe I need to be a party.
you need to be a party?
I reside at 181 Minnesink Avenue, which is right next door to 177 Minnesink Avenue, which is the other end of the property that's on Minnesink Avenue, which extends to Worthington Avenue, and the other end is 133 Worthington, which is adjacent to my backyard.
Okay, so you are adjoining this property or are you a lot or so away?
I'm right next door. I adjoin, my
Okay.
property adjoins the subject property.
And again, based upon, I'm hearing that, it would be my position then that you be given party status.
My formal name, I guess I changed it when I got married, but I go by Ann Luigi because most people know me by that name, but I guess legally it's Ann Nicholas, Nicholas.
And Ms. Nicholas, I'm spelling your first name without an E, is that correct, or does it have an E?
No E.
Okay. All right, anyone else here wishes to have party status? Yes, sir.
Yeah, excuse me, Tony Greer, GRIZR. I'm at 164 Minnesink Avenue, and the property in question is across the street and one or two houses up.
Could you spell your last name again for me, sir?
GRIE.
Okay. Again, because of his proximity to the location, I would probably recommend you give him party status also. Okay. All right, anyone else? Yes,
Hi, my name is Chris McKenny,
how you spell Chris?
CHRIS,
And last name MC?
MCKENNEY.
Okay, address,
Address is 173 and 175 Mini Sink Avenue.
Oh, God.
and where would you be in location to this property?
Immediately adjacent to the property.
And again, I would say based upon that, that those individuals or that individual should be also granted party status.
Thank you.
Thank you.
All right, anyone else?
Well, this is Christine Greer, Tony's my husband, I'm co-owner of 164.
Hold on for one
Yes, sir.
second. Who's your husband?
Tony Greer,
Oh, the individual who just, okay.
so I'm co-owner of the home, 164 Minnesink Avenue.
And how are we spelling Christine?
CHRISTINE.
Thank you. Okay, anyone else? Anyone else? Okay, looking through the room, I see no other hands being raised. So we will assume anyone else here is either someone who's going to listen to proceedings or be a public commentator, which they are entitled to do, provided they meet the requirements. All right. That being said, before we begin the hearing, I'm going to have 3 exhibits that have been pre-marked, reviewed by the stenographer, and I will review and make them part of the record in this matter. Board exhibit number 1 is the application that was filed in this particular matter with a date of February 6, 2023. It is a multi-page exhibit that has maps and various attached information, including a site plan development statement of purpose, requests for any variances or waivers and other information. The next exhibit is board exhibit number 2. And that is the proof of publication verifying that the property for this hearing was advertised once a week for 2 successive weeks. Not more than 30 days before the hearing, or less than 7 days before the hearing. And specifically on March 28 and April 4, 2023. And exhibit B3 is the affidavit of posting indicating that the property was posted on March 27, 2023, which is more than the 7 days in advance of posting, and attached to that affidavit of posting is a copy of the notice. So those are the 3 exhibits that are being introduced on behalf of the township. They are noted as board exhibits, if you will, also indicate they could be considered township exhibits. That being said, and since we have parties here who will be given party status, do you have any objection to those exhibits? And if so, what are your objections? All right, I'm hearing no objections, so that I'm asking that the exhibits be made part of the record, be introduced and admitted as part of the record in this case. All right, that being said, if the applicant is here, obviously they can proceed in whatever fashion they deem appropriate regarding the application.
Hello, I'm John.
Here.
I'm Jonathan Kirkwood, and I am representing my family as owners of Shawnee Golf Resort, and this is my general manager, Rob Howell. So I would say together we are the applicants. Shall we sit?
Sure, yeah.
Seems odd. Forgive my informal attire. My kids had track at Eastburg today. Okay, so I just felt very.
Thank you.
Frankly, I thought Attorney Kursek characterized.
Make where you at,
I'll make it sure.
raise your right hand, you sound swear or affirm to tell the truth, the whole truth, and nothing but the truth.
Yes,
Thank
yes.
you.
I thought Attorney Kursek characterized the situation perfectly. And I would say maybe as an extra comment, I think it's an anomaly that this particular lot extends all the way to the Minnesink Avenue side. And if that particular anomaly is material to anyone's point of view on this topic, we'd be quite interested to know that. Because the two buildings on the parcel, the one closest to Minnesink Ave, we have no plans to do much of anything with. It's employee housing now, and it would stay employee housing, so to speak, as far as we're concerned. I.e., no proposed changes there. And
30 plus rental.
yeah, they're just like everyone else in town, so to speak.
Now, let me ask you this, so we're sort of consistent, and if you're gonna say something, Mr. Howe, which you certainly are welcome to say, you will need to be sworn into.
He was fine.
I was sworn into both at the same time, okay? Just give us a little bit of snapshot of the project, where it is, what you're doing. When you filed your application, there was a statement of purpose, et cetera, and then if you want to look at that, if you have it in front of you, now I can give you a copy, but put a little bit on the record as to what we were doing here and why.
Okay, sure, have to read it again, just get me. Will I read it out loud for the record?
Please.
This conditional use permit will allow the historic Shawnee Inn and Golf Resort to use the property at 133 Worthington as part of its resort. A resort use is allowable in an R1 zone by conditional use. The property is contiguous from property that is owned by Shawnee Inn and Golf Resort and already operated as part of the resort. It, along with other Shawnee Inn and Golf Resort properties in Shawnee, Delaware, have been operating as a resort since before the zoning map was created. The property at 133 Worthington Ave and its building, in this case buildings, that I note my own comment from before, and its buildings will be added to the inventory of the Shawnee Inn and Golf Resort facilities and used for guests for the number of nights they would like to stay at the resort. Alternatively, the property and its buildings may be used as employee housing, both in keeping with the resort use both in keeping with the resort use as defined by Smithfield Township. It'll be available 365 days a year. Shawnee Investments is the current owner, and the property will be leased to Shawnee Inn and Golf Resort. And there are no plans for future changes or changes in ownership. And I just might note for posterity, it's quite interesting. I'm not 100% certain of this, but it's my understanding that when my family moved to Shawnee in 1977, the old timers used to refer to that home as the McClintock House. And I want to say that Mr. McClintock was one of C.C. Worthington's very first front office managers at the inn, which is to say, it has been being used as resort staff housing for more than 100 years. I thought that's kind of interesting, keeping with Shawnee preservation and its goal to preserve the timelessness and that sort of character of our town. Thank you very much.
All right, let me ask you a couple of questions, and of course, the parties and the board will be able to ask you some questions also. There is going to be no change in the building footprint, is that correct?
Correct.
And there's going to be no other earth moving or development proposed, correct?
Correct.
So then this project would not involve any stormwater issues.
No, sir.
It would not involve any sanitary septic issues.
No.
It would not involve any water issues.
No, sir.
Or it would not. Well, let me not ask you this. Let me ask you this about traffic. Tell me about traffic. Is this project increase or decrease traffic or what? Tell me about that. If you know, don't be guessing. I'm not just try to help everyone here in the room to understand what this project's about.
I think if anything, the traffic goes down, not up, if you compare it and contrast it with the residents of this property over the past 5 to 10 years, who I knew well and was neighbors of, but they were rather busy, had more than one car, and would drive in and out much more frequently than your average resort guest would.
And how about any lighting? Are there any lighting issues where lights on this project, if there are any, glare on adjoining property owners or anything like that?
No, sir.
Board, do you want to ask questions now? And then we'll have the other individuals ask questions.
Jonathan, the zoning officer brought this to our attention, and quite honestly, I don't really know what to make of it. It's section 511 of our zoning code, supplementary regulations applicable to other uses. Resorts where permitted shall be subject to the following standards. And one of them is B, no building activity area or recreation facility shall be erected within 50 feet of a road line or within 100 feet of a lot line. Obviously, the inn doesn't conform with that at all, because right across the street, you have several buildings that I'm sure are quite close to the street and don't conform. And I don't really know what to make of it. Rhonda, can you give us some advice on this?
Help me out here again, 50 feet within the road or lot line?
It says, no building activity area or recreation facility shall be erected within 50 feet of a road line or within 100 feet of a lot line. Of course, these buildings were erected long ago, and so were the buildings across the street in the resort, and I don't think any of them fulfill these requirements.
If they were illegal uses at the time before zoning occurred. Okay. Then they would be considered grandfathered, if you will, based upon that, but they have to be a legal use. And you can't have an illegal use like some house with a beer sign, if you will. And then when you change zoning, it was okay. No, it has to be legal to start with. So
Well,
if these were all legal and they were within these hearings, then for these areas, then it would probably be a non-conforming.
the question is,
But you, as the supervisors, if you decide this, can say, we're gonna grant this, but we need you guys to go get variances for those lot lines
from the zoning hearing,
from the zoning hearing. You can make that a condition if you want. Okay. All right, any conditions or any questions by you, Jacob? I'm sorry.
No, you're okay. I mean, I think that the point that the zoning officer brought up to us, although it was just a day or two ago. I think that's a valid question, but I think it's presumed that these were legal non-conforming uses before the ordinance was adopted, but I mean, my only question is like, is this parcel itself directly contiguous to the rest of the in parcel, or is it naturally subdivided by the road?
Well, in the, other than that parenthetical where it says in the application itself, across the street from, you
Yeah.
know, across Worthington Street. So yes, it's contiguous across Worthington Street.
So it has a road between the two pieces, if you will.
Yeah.
Say that. Okay. All right, Brian, if you can hear us, do you have any questions?
Not really, but I think that the people who have just indicated they'd like to speak should be allowed that opportunity, and then maybe the board itself can speak afterwards.
Okay, well, we're gonna do that. We're trying to go in order, so.
Well, I'm just thinking about there may be some good reasons for or against, and we really want to know that before we go and make comment.
I don't think any of us were making any comments by asking questions, but we'll certainly follow the best.
Some of the comments were a little bit leading, but that's okay. Anyway, that's what I feel we should do. It's
Okay, all right, we're fine. So we have the questions asked by the board. Now we'll go to the parties. Do any of the parties here want to ask questions? And I want to emphasize those are questions, not some speech, not some statement that you want to make. Questions of these individuals based upon the testimony they gave. You can't go on to some other tangent if you would. Based upon their testimony, you can ask them questions. If you want to go into other areas, then that would be your testimony to do. All right, so we have Ms. Nichols. Go ahead.
I just want to make a comment that I personally am not at this point prepared to ask questions based on what was said so far. But I may have questions as this discussion continues.
Okay, fair enough. That's a fair statement. Anyone else have any questions of these individuals? All right, it's Mr. McKinney, is that it?
Yes, I just want to ask, I want some clarification about the use of this property. Because on the one hand, I think I'm hearing that it might be used for employee housing, but on the other hand, it might be guests of the inn may be put there, so how can you have employee housing that I would assume would go on for months or even years? And at the same time, have guests that might come in just for the weekend or for a week and then leave and then other guests come in, so.
Totally understand that, understandable question. Let me try and compartmentalize the answer. The Shawnee Inn and Golf Resort offers as its inventory roughly 81 rooms in the big white hotel, and then approximately 20 odd rooms in a series of what we call outbuildings or cottages. Already in use today, we have the Evergreen, the Sycamore, the Cedar, and the Worthington, which happens to literally be across the street from what we're talking about now. This building would fall into that bucket in the ideal case. So it would be yet another cottage for hotel guests to rent by the night or by the weekend. Or else, you know, ideally. Having said that, we consciously included staff housing among the options by virtue of the fact that that is permitted in an R1 with a resort conditional use. So we didn't want to obviate the ability to do either. But the idea would be to have it be typical hotel guests.
But so we're clear, you want to be able to do both if you need to.
Yes, that would be an option. I mean, would you like me to give an example of that? For example, let's say we were trying to hire a chef, a head chef. Many people love food and perform that career above and beyond the money. They don't do it for the money. But we would be able to maybe attract a better chef by saying, hey, we have a beautiful opportunity for you to have staff housing in this historic town that we love so much and spend so much of our time and energy trying to maintain its history, elegance, and charm. Frankly, none of which would be detracted by this application.
Let me ask one other question, and the other individuals can certainly have questions too, but I'm thinking about it as we're talking. Tell me about off-street parking. Is this project going to create any off-street parking issues for neighbors?
No, sir. Adequate parking in the driveway. Off-street parking is a really fun topic in my village. I'd love to address that at some point, perhaps.
Okay. Are any other parties going to ask questions about what was said by these individuals?
Yeah, I have, Tony Gray, this got a couple. Sure. I don't have them separated from all my other notes here, bear with me.
That's okay.
So,
Good to have.
it mentions, I mean, on the maps, you have, 133 circled, across from 138, across the street, but not 177. I think what I heard you say is it's only the 133 property that you're asking us for?
At this moment, the answer to that question is yes, meaning we have no intention of using the second floor of the, where there are currently employees living, for any other way. To be perfectly frank, I would like the ability to perhaps consider upgrading that space and utilizing it in the same manner. With the conscious thought that we don't impact our neighbors in a negative way.
Right, so with the, and I guess this is the lawyers, would the approval of 133 include the ability to use 177?
If they want to use 177, they have to come back in again, unless I missed something. Okay, as to where its location is or what, but if it's an R1 and it's not a resort use right now, and they want it to be a resort use, they have to come in with another.
Right, so it's not that whole land package including both of the lots.
Unfortunately, I can't answer that because I'm not familiar enough with that area, but perhaps these gentlemen can answer that question.
Yeah, it's an interesting question. It's one lot.
No,
It is, I believe, able to be accessed from both sides sort of indefinitely, so that as sort of a freeway. Again, I'm looking to the group here to make sure the impact is as painless as possible of this conditional use application we're making. And, I'm starting from a position that down the road, when our ship comes in and we have the funds to upgrade that space, I would like to be able to make that into another cottage along the lines I've described already. That's my answer.
Yeah, no, I get it. I just was wondering what the request was here. So at this time, 177 would not be included, we want another hearing and. Right.
Ron,
don't believe it would. I cannot confirm or deny that. I do not know the answer to that question.
That's like president needs.
Yeah,
I need the application for a second. Let me look at that.
I've never been prepared to tricky dick, but that's quite funny.
Ron,
This is
would it be
for-
legal to divide one lot like that and say you can have a conditional use on one part of this lot, but we're not granting a conditional use on the remainder of the lot?
I appreciate you saying that. That brings clarity to the question. I'm hoping the answer is no, and the whole parcel gets the conditional use, ideally.
I have here.
You know what your
Yeah,
position is.
that's what I mean. I'm coming in the front door. This is non-confrontational. I'm shocked.
The application is for location of property at 133 Worthington Avenue. So now if that's 2 lots, 5 lots, or 6 lots, I don't know. The application says 133 Worthington Avenue.
If you look at the official map for the township, it is one lot.
And there's another building on it that has a, I guess, in
Or does the other building have a
911
different,
address, one.
does the other building have a different address?
Yes, it does.
Then it's not part of this application as far as I'm concerned.
Oh.
Right, yeah, I was wondering about the legality. So if they're all on the same lot, it's approved for 133, is it automatically approved for 177?
And again, the application is for 133, but
Okay.
133-135 or 137, yes. As far as I'm concerned, my recommendation to the board, because I don't make the decision, I'm just the
Right,
the appointed individual to make comment, they can make the decision. If they want to make both lots part of the case, they can. They're the judge.
okay.
I don't think we can unilaterally do that, but it is just 133 Worthington that's on this, so that's all we're going to consider, and I think
That's fine. We're happy to only consider that single building today for this proposed conditional use.
Okay, yeah, I just wanted to clarify, and I think I got it. Yep, my other question is,
Mr. Greer, could you speak up just a little bit?
I'm sorry, yeah,
sir?
I'm talking down. So my other question was, it says the property currently has 3 buildings on it.
Very small little garage, kind of tucked in by that tennis court.
It's a garage, it's the
one building and then the other.
All right, so, so there's mention of, that portion, and then the other building is a rental property. So I understand your intent was, probably be both, but I think we clarify this just for the one. All right.
Yep.
Aside from my, alleviation later, let me see.
We'll let you ask other questions later if you think it's something, so don't be jammed that you have to think.
Yeah, I didn't separate them, I didn't know how to say.
That's okay, that's not a problem. All right, yeah, okay, you can't, you're welcome to ask questions, but we can't do 5 or 6 at a time. Answer all your questions at one time, so the record can be clear as to who's saying mine. Go ahead.
But as the conversation goes on, issues come up, and that's why I'm asking.
All right, go ahead.
A second question, not 5 or 6, and that is, if there is no dividing line with that property, then when that property gets rezoned, it would be the whole property. I mean, it seems pretty obvious to me, because then how could you say where the dividing line is between the property on Worthington and the property on Minnesota?
The property is not being rezoned, it's being given a conditional use if the board believes that that is proper. It's not a rezoning, it will continue to be R1. However, this use, if the board believes is proper, would be granted conditional use, not a rezone.
Right, but it's there is no dividing line in that property, so if you grant the conditional use, I'm sorry, I don't know the zoning language. You grant that, and there's no line, then it's gotta be for both.
I thought I heard that the other property has a different street address.
It does.
All right,
But
so
if you
then-
look on the map, there's no
I
dividing.
don't care what the map says, if it has a different street address, and the applicants have agreed, we're dealing with 133 Worthington only.
But if it's a legal lot, I mean, it's allowed with all three zoning laws. So shouldn't the other two
There's no
buildings
division
be
in that
included?
lot.
I'm sorry, everybody's not it. Take your turn,
I
okay?
apologize.
Ron, can I
You're
have
gonna
that?
wait for your turn, Pam.
I'm not sure I understand, so there's no division between these two lots, is that what you're saying?
No, for what?
Correct. It's one part.
I think it's one parcel, we don't know.
Excuse me, I'll just make a comment here that 177 menacing occurred when it was 9/11, safety, all the addresses in the county were redone. And that's when that particular building became 177 menacing.
Can I ask a question? Right, like,
Hold on, we're
That house.
we're gonna wait till the other parties finish unless anyone else is.
I just wanted to clarify how it became identified as a separate address.
Okay.
my best friend was an attorney for your father, lived there for a long time. And then there was a family after that that lived there, his kids went to Notre Dame with my kids. Why wouldn't you just keep it the way it is?
We have a great amount of demand for outbuildings. And these are the type of clients who aren't like Airbnb people who are gonna party and trash the place. These are Shawnee Inn guests.
But you can
We
also
have
get good.
their, hold on a second, please, I'll answer you. We have their information, we have their identification, we know when they started, we know when they left, and we almost always have repeat business. So why wouldn't we keep it the way it is? Because we'd like to exercise our right within an R1 to utilize a building as a resort, which is a conditional use. That's the definition of what the American system is all about. That's the answer.
Let me ask this just quickly, is the current use of record as a single family dwelling? Is that,
The most recent tenancy was that of a single family lease. Yes.
Excuse me, I would like to speak to that. I've lived next to that property for over 25 years. When I moved there, there was a single family occupying 133 Worthington. And then after that, there was another family occupying 133 Worthington, and they resided there approximately 10, 11 years. So all the while that I've been living there, that property that we're talking about, that building, has been occupied by single family.
That's what I said. I agree with you.
Thank you.
Yeah, so again, it's in R1.
25 years, which I think establishes somewhat of a precedent. Because I don't think we want to go back to 100 years ago when C.C. Worthington developed this whole thing. Because at that point in time, Shawnee was a very exclusive community. And I don't think we want to go back to that.
I don't disagree. I guess what I'm asking though is not a matter of, precedent, a matter of fact in the township record is presently a single family dwelling, or is it considered part and parcel of the resort? Because if it is considered part and parcel of the resort, there's really no need to continue with a hearing if that the existing use. That's
I think it varied between, over the years, please correct me if anyone has older history, it began in the old days as resort use, in the sense that staff lived there. And in the interim, it's vacillated between that and single family use.
that's what I'm asking, what is precluding you from exercising your right now?
I don't know.
I think that they want to have, instead of 31 days minimum, they want to be able to
Oh, yeah.
turn people through it on a daily basis.
What did you say?
I said, I don't want to speak for,
Sounds good to me.
right? But so instead of having a 31-day minimum occupancy, they want to turn it into a daily.
Correct.
No, I understand that, I guess I'm just wondering if it presently exists and is considered just part of the resort as the use of record, then there's no need for the permit to use it that way.
I see that. No, I mean, we're happy to proceed as planned in the manner at hand.
I just don't see,
I don't think.
But it's not used as a daily rental or as part of the resort.
I'm sure, I understand that that's not the present use, but there are. I guess what I'm saying is, whenever, in a more typical circumstance, you have a lot that is your, car dealership or something, you would need a change of use to make it a restaurant. So, but if for some reason that car dealership already had a restaurant, then you wouldn't need to change of use and have it happen. So what we're dealing with now, my question is whether or not it actually changes anything, or if there's any legal mechanism that precludes you doing what you'd like to do. I think that might require,
Excuse
Zoning
me, but I
officer's
think
presence.
if this conditional use is allowed, I think it would change for the people who live on properties adjacent to it. It would change for me.
we can certainly proceed to the testimony of the parties if that would help answer, or provide more context.
That's up to you,
And
Madam Chair. You want to continue?
Yeah, let's do that, because this is becoming circuitous.
So let's see if there's anyone else who's a party that has any questions of these individuals.
I don't know if it's a question for individuals or. But if in fact this was granted, but that also grant others to, let's say, create a corporation and then lease their house to that corporation and do mixed use properties on the rest of the block?
No, that would require its own procedure, very unlikely, it would require this type of hearing for that, planning commission reviews, et cetera.
So it'll be the same.
Correct.
Because we're asking for the same arrangement, but it doesn't set a precedent.
Correct, when the conditional use is granted, it's only for the individual property in question and not necessarily anything else that they're site specific.
I guess I have a question.
Sure.
Would the property be, and
I'm sorry, your name, please?
Oh, Christine Greer, I'm sorry. Is the property gonna be improved at all? Because I don't see any real, I mean, attraction. The property that we're talking about is kind of an eyesore as it is. So what would be different? There's a pond that forms in the middle of it every time it rains heavily. And there's gas cans outside. So what's the difference? What's gonna be the difference? If you, are you gonna fix it up?
Yeah, I mean, wherever the status quo is today, it'll only get nicer in terms of curb appeal and so on. Yeah, which I think is enhancement, right?
Yeah, if it is, if it's not gonna just be the backyard of an Airbnb.
I think that could be a consideration for a reasonable condition that it would be improved to match the aesthetic of the rest of the resort. I don't think that would be a problem.
No worries at all.
No.
Any other questions by any of the parties? All right, so then let's go to the parties. Does anyone here want to testify as to this particular matter in whatever fashion you deem appropriate? Let's start with Mr. Holland. Do you want to testify in this matter?
Yes.
Raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please come forward, sir. Okay.
I will dispute your history of the McClintock house. It's always been a single family dwelling.
I wasn't saying anything.
It states very clearly that there is a prohibition on short-term rentals in that area. It's an R1 zone and it's always been a single family dwelling. To change this, I can't see where it benefits the community, any of us that live around it. None of us signed on to have a resort right next door. And I would, one question I would have is, you have lots of property in Shawnee, where does it end? Where's this gonna end? I think it should end right here and not, they should not be given this.
And tell me how this harms you.
How this harmed me.
Correct. burden of proof that you heard me state at the beginning of the hearing, that
Well,
you have to show the harm you are getting is more than would ordinarily be considered.
the harm that I would have,
Yes.
to have a resort right by my house. Who can tell me that it's not gonna harm my lifestyle? And where I live, how quiet it is. It's very quiet, it's a nice neighborhood. Who can tell me that there's not going to be noise? And there's not going to be parties? I don't think you can guarantee that.
All right, very good. Or do you have any questions of Mr. Holland, or gentlemen, you also can ask questions of him if you wish.
And just to note that I agree it's a single family, it has been for years, and I'm on record agreeing with that point, so I felt odd to have that be the first comment. And then secondly, within 150 meters of your home and my home, and I believe everyone's home in this room, there are at least, say, 70 Wyndham timeshare units in whom there are, let me just finish, please, every week, complete strangers in our town. So to the extent that that's a good thing or bad thing, this is not a referendum on timesharing, but in the milieu in which we live are those types of people. Now, keeping them to a minimum is also my goal. You have to understand, I'm trying to draw a distinction between Shawnee and Golf Resort clientele, shall we say, and the typical Wyndham guest. They're all wonderful people. And I'm saying we're trying to do the best we can in our community. In a sense, I mean, think of Colonial Williamsburg. Think of these places where there's great history, great interaction between the for-profit businesses and the town. That's a dream. That's a goal. I don't know.
That's what you want to turn our village into a for-profit business.
No, I'm saying exactly the opposite. No, I said Colonial Williamsburg is an example I gave just to display the way a town has residents who are happy and a whole bunch of tourism and people who come for whatever the reason. I can think I'm just saying, I'm just trying to say that there are examples of places in the world, and frankly, I think our village is amazing, and I would do nothing to spoil the timelessness of it. I think it's Norman Rockwell personified. But again, with all due respect, are you trying to say that the previous occupants of this building represent the idea we have for it is a step in the wrong direction from how it has been in the past? I'm just curious, you think this would be a step down?
I don't think you need to go there with the previous occupants. I wouldn't bring that up, John.
They're friends of mine, and I'm still in touch with them. I'm just saying that their upkeep wasn't great. Is that not
I agree.
fair? We're in agreement.
And just for future discussion here. Have a discussion between you were to ask him questions. Okay, and he's gonna give you answers, that's how it works, and then at the end, people can make a comment or a speech. Okay, very good. All right, anything else, Mr. Holland?
No.
All right, thank you so much. All right,
Okay, thank you.
next we have Ms. Nicholas.
Raise your right hand, please. You do solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do,
Thank you.
to the best of my knowledge. Okay. I have a lot of papers here, but I promise you I am not going to read everything on all of them. But I do want to make you aware that my
It's not comment, questions. You have questions, or I'm sorry, I'm on the other side. Go ahead, keep going. On another area.
Okay, all right. I know you have to compartmentalize things here. All right, so all of my comments, everything that I'm going to say that I've prepared already is related to this document, which was posted to the tree at 177 Minnesink Avenue. And it describes notice of public hearing and public meeting on a conditional use request, a resort use in an R1 low density residential zoning district. Okay. So the first thing that I wanted to comment on, and I numbered the lines in this just for my own easy reference. Lines 8 and 9, the property is currently owned No, that's not it. There are no plans for any changes in ownership. It's actually the end of line 8 and most of line 9. There are no plans for any changes in ownership and no development is contemplated at the site. So when I read that, I immediately dismissed the comment about there being no development, no plans for development, because we know that plans change. And this is not the first time that the township has had a request for changes to the use of this property. Back then, there was a request to put apartments in the garage storage area in the building that houses the two apartments. And at that time, the supervisors, in their wisdom, denied that request, which is a good thing because that property then flooded. So all of the money, all of the effort that went into developing those apartments on that ground level, not only, you know, the Shawnee Investments put in, but also the people who would have been occupying those apartments, they would have been flooded. So there are other properties in the area that are owned by the same applicant. And so my question would be, if this is allowed, then does it stop there? Or would there be additional requests? Because as I said, plans change. So the next comment is about lines 15, 16, and 17, which is saying the property is contiguous. And I'm not sure what that means, what it is contiguous to. And across the street from a property that's owned by Shawnee Resort, it has purportedly been operating as a resort used before zoning regulations were adopted in the township. I don't know when the township did adopt zoning regulations, and so I dispute that. I question it, and as I said earlier, I've been living there for over 25 years. Suzette Wong and her family were most recently family long-term occupants of the property. And I think they were there for like 10 or 11 years before they were asked to leave so that renovations could be done. And then prior to that, the Pete and Mary Fodness family, they were long-term applicants. And I have to say that never had any issues with either the Fodnesses or Suzette Wong and her family. They were quiet, no issues whatsoever. So the idea that this property was purportedly operated as a resort, I dispute that. So the next thing that I want to comment about is that this is a low density residential zoning district, low density. I want to emphasize that. And I think by allowing conditional use property that goes from Menacing Avenue to Worthington Avenue as an extension of a resort is inappropriate. I consider it encroachment. And I think it may lead to spot zoning. I was on the planning commission for 5 years. I was the chair for a couple of years. And at that time, we frowned on spot zoning. And I'm kind of surprised that the planning commission approved this. Spot zoning is not desirable. It wasn't desirable when I was on the planning commission, and it's still is undesirable. Okay, I'm gonna stop there. I don't want to ramble on. This brings me to the ordinance number 306, which was approved by the township supervisors. And this ordinance states, in addition to the prohibition as outlined as section 304, this chapter, chapter 27, the zoning chapter, short-term rentals are prohibited in the RC residential conservation, R1 low density residential zoning district. This is your ordinance that you put in. And so my thinking is, what were you thinking about when you initiated this ordinance that says no short-term rentals in an R1 low density residential zone district? So if it was to prevent party houses, then why would you drop one right in the middle of a residential area? And I think that if you allow this, you're going to open a can of worms, because there are going to be challenges to this ordinance, because then everybody on Minnesink Avenue and on Worthington Avenue, we're all going to want to be able to rent our properties short term. If I go away on vacation and I need some extra bucks, maybe I want to rent my house. I'm not inclined to do that. I don't want to do that, but I'm just saying, we want long-term, stable residential occupants in a low density residential area. Okay, now, we talked a little bit about whether we're talking about the entire lot or just the front lot, etc. But I want to get on the record that this lot is problematic. It has a storm water management issue. And my note here says, problematic property, Lake Lambert, AKA Mosquito Farm. And Lambert, out of affection for Gary Lambert, who was referred to as Mr. Johnny, lived there a long time. And I'm sorry, I could not, put my hand on these pictures, but I have a picture of Gary Lambert kayaking in the water in the lot that is now referred to as 177 Minnesink. And this standing water is allowed to dissipate naturally, or if it's there for a long time, one of us will go over and we will dig a trench from the water to the broken stormwater drain that's on the Minnesink Avenue. Now, standing water like this becomes a mosquito breeding ground. And for years, I have been treating the standing water on this property with BT. And last year, Monroe County Vector Control came out and treated the property. It's also prone to flooding. The floods that we had when the New York reservoirs were voided, this is what flooded. And so I think that it puts the adjacent properties at risk. So my next comment is that, guys, this is my home. I don't have another home that I can just pack up and go off to when issues arise, with an adjacent property. It's the only home I have. I'm not planning to move and not planning to sell. And I do not have the resources to erect a barrier around the perimeter to protect my privacy, or to try to abate any noise that might come from this property if this conditional use is granted. And I'm not asking for anyone to, put a barrier in for me or anything like that. I'm not looking for anything. I'm just saying, I'm not in a position to move. I don't plan to move. This is my home. It's the only home I have. And I value my quality of life. I live in my backyard. Anybody who knows me knows that I'm a gardener, and that's where all of that activity goes on. And, I haven't even touched on property values. How might this conditional use impact our property values? I just have a feeling that it's not gonna increase the property value with a conditional use resort smack dab in the middle of this residential community. I mean, that's what Worthington Avenues and Minnesink Avenues are. We have a nice little family-oriented neighborhood going there with children. If you look at the township map, and I have a very poor version of it and I circled the property. And you can't really see it, but I colored it in red. And because it sticks out like a sore thumb. You know, this conditional use in a low, density residential zone. So, and then I have, I wanted to show you pictures. And that's why I was asking about PowerPoint earlier. This is my backyard. And you can see that, you know, and I'll leave these with you. You can see that it's virtually my backyard. And there's a fence there, it's a partial fence. I'm not sure, you know, what the intention was by putting a partial, a fence in. So, and I did use, you know, township documents that were on the website to, do my research to make my comments. So, I want the supervisors to consider now, Jacob, I don't know where you live, Robert, I don't know where you live, Brian, I know where you live. And I just consider, what if this happened where you live? What if the property right next door to your home, your sanctum sanctorum, your sanctuary, you know, all of a sudden became a conditional use attached to a resort, short-term rentals? Would you like it? You know, I'm not asking you to answer that question, but I'm just saying, would you want to experience it in, you know, the increased traffic, increased noise? And, you know, the other thing I'll mention is, you know, the condition of Minnesink Avenue and Worthington Avenue, the roads themselves, it's fair. And we're not sure how much increased use we would see. But, you know, we kind of, you know, bump along on the roads now. Will they get worse? And then who is the repair and maintenance of those roads going to fall to? It's going to fall to the taxpayers. The resort's not going to pick up the tab for that. So I just think it would be a bad decision if you approve this, which is just going to open up a can of worms. Because people will want to be able to do this not only on Minnesink Avenue and Worthington Avenue, but throughout the entire township. So,
Your availability, you said is still about 7 and I wanted to.
Yeah, my avail, but I can probably stay till 7:30, but not later than that. I have to be in Harrisburg.
And just some tangent,
one slide, I'm sorry, this is the last thing.
I just want to make sure.
Okay, what is the desired outcome? To preserve the unique nature of this neighborhood. No conditional use that adversely impacts our quality of life. And that's what I have been trying to convey, is about my quality of life or our property values. And we want to maintain the integrity of the neighborhood. You know, Jonathan, just like you were saying, you know, it's iconic. There isn't a little neighborhood like this, I don't think, anywhere in the township. It's historic. And it's worth preserving the way it is. And once it changes, it can't go back. There's no going back. So, if you want this, I can leave it for you, but,
and
That's it.
to answer one of your questions, because Jacob was not here at the time, but Brian and I were, why we outlawed short-term rentals. And the reason was because in the short-term rentals, they were proliferating at the time. There was nobody who was in control of the property. They were usually purchased by off-site landlords and then rented out online on Airbnb and other services. It's
And
different than this only because the inn is responsible, if this was passing, for controlling the guests and controlling the property. So, you know, we reached 3 different ways that, or let's say 2 different ways that you can have a property that has short-term rentals. It can't be short-term rentals, just as short-term rentals. Maybe this, it could be, I'm not saying yes or no, but that's the supposition that we're going under. And also, if you look at the corner of Worthington where the Stony Brook Inn is, that's bed and breakfast, which is allowed because the proprietor lives on the site.
And I would assume that it would have been grandfathered in, but there is the potential for other properties that are on Minnesink Avenue
Can I just say this, that they would have to be over 10 acres.
for short-term rental.
But not short-term rentals that are outright prohibited in the R1 zone, but what I'm saying is. A resort lot area has to be 10 acres.
They're not prohibited.
So you wouldn't be able to, someone who just wants to rent out their house wouldn't be able to say it's a resort unless they had 10 acres, in which case. No one else would.
Okay, well, I still am of the position that if you allow this, it's gonna open a can of worms. So, thank you very much. Thank you.
The board should be aware that in the development application that was filed by the applicants, they indicate that the occupants of the property will be for 31 days or more, which meets the township's requirements of short-term rent. You can have a rental.
Yeah, that's not a short-term rental.
Well, but I understand that, but in their application, they're saying the occupants will be 31 days.
Actually, that doesn't jive with what I understand their, saying.
Okay, well, this is your application I'm reading.
And that's the other building.
Well, that's the 177.
Yeah.
Okay, so we're not even worried about it.
That's the other.
Yeah, I'm worried about that one.
Well, 177 is 30 days plus.
Anybody should.
Exactly as it is, I mean.
Do you have any questions of Ms. Nichols? I'm sorry.
No, thank you for sharing.
No, thank you.
Okay. All right, we have then next. Mr. Gear, if I'm saying it right.
Yeah, Greer, I don't have any testimony, I just have general, comment.
Okay, that's fine. How about your wife? Any questions? Okay, and then finally, then we have Mr. McKinney. Do you have any testimony that you want to present?
Sure.
Okay, come on up.
Raise your right hand. You do solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I affirm.
Thank you.
Let me just start out by saying I love the Shawnee Inn. I think it's a great place. I've stayed there numerous times. But I'm gonna want to reiterate what Ann, as I know her, said about the community. This is a residential neighborhood. And it is a community. The Shawnee Inn is, if you walk from this house to the Shawnee Inn, I don't know, it probably takes 5 or 10 minutes, depending on, how fit you are. We had a grandchild and expecting another. This, to have a short-term rentals next to us, it's just, I mean, to me, I'm just shocked at this, really. It's not what anyone would want in your neighborhood. I'm sure of that. I don't have to ask you, you don't have to swear to it. I'm pretty sure none of you would want a short-term rental right next to you. And what concerns me too, although I will say, I mean, I am glad that the inn would be running it, but what concerns me is that, so what stops the inn from buying another house, or maybe they already own it, and turning it into a short-term rental, coming back here a year later and asking again, and you've already established a precedent for doing it, so why not do it again? So think about the community. It is a gem of the community. And what makes a good community? It's the people who live there, the long-term people who live there. You know you can trust them. They know they can trust you. It just makes it just a pleasant and a great living experience. And I think that's what we all want. And that's what we've found there in Shawnee. So I would just ask that you not erode the integrity of the community. It's just something I think that benefits the entire township. Thank you.
Gentlemen, do you have any questions? No, thank you.
No, sir.
Just to be clear, any change of use would require the same set of hearings, so it technically does not set a precedent each time there's a hearing like this. The applicant has the burden of proving that it meets the requirements, and then those that would object, the burden shifts to them to prove as to why it would be worse than reasonably expected from that type of use. And then the board will make its
Let me
decision.
ask the applicants this, because now that it's clear as to 177 Worthington, Minnesink versus the other property here, so this is your position that you, let me use short-term rental for lack of a better word, that you are going to be able to rent this property for just a few days at a time, and it would not be short-term rental because you would consider that a resort use?
Yeah.
Is that where you're coming from?
Yes, for 133 Worthington, yes, and we would be willing to entertain the notion that the building at 177 Minnesink not be party to this decision.
Well, that's already been agreed to, as far as I'm concerned, that's what I was recommending to the board, but again, it's up to them. All right, so that's where that bugaboo is, the resort use versus the short-term rental, so that property that is at 133 is not going to be for 31 days or more, that was the other property.
Correct.
Yes, sir. Okay, now, Brian, you're here, you have any questions?
I do go back to that property, and it was going to be developed. I think that Amy Kirkwood, in fact, Jonathan, was going to build her home there. And we decided, and it was decided, DEP got involved, that it's just a flooded place. It can never be safe from standing water or steaming water, streaming. We denied that on those grounds, but we never got involved with short-term rentals. When you say short-term rentals, my question's simple. Where do they check in? At the inn?
Yes, sir, Shawnee in front desk.
Just like I would if I were going to stay for the weekend.
Yeah, just like if you're going to the Worthington or the Evergreen, Brian.
What's your security? At the inn, you have security on grounds. How about out there?
Well, they travel around, I mean, they move.
Well, they don't travel around that much. Trust me. I've had coffee with none of them. Okay? I'm looking for some kind of a consistent security arrangement.
Is that something you want to put in as a condition then?
Not me. I'm just saying that I would like to see something like that, sure.
We currently have Brian, we have our night auditor already doing the rounds, which include the Worthington, which is, as we know, across the street next door. So.
Oh, yeah.
Adding this property to that road is not a problem, and we would of course expect to do so.
So, I mean, so what, every 4 hours or 2 hours they go by? I call the Shawnee Inn. I've been in Shawnee Inn when the only person there is somebody at the front desk. If you got a problem over there, who do you call?
I mean, they'll call me, they'll call someone else who's close by, they'll call John, if they have to.
They like to call me, Brian, in the middle of the night.
Well, no,
Yes,
you designate someone.
Yes, we do. We have dedicated manager on duty, and we have night auditor, and there's a protocol in place that has the capacity to expand to fill this particular property.
John, you realize the property next to me for long-term rental. Leslie built it with the idea she was going to do a short-term rental, and she can't. She rents it out now by 30 days. to kind of set an example.
All right, so is there any other questions by anyone? All right, then we'll move on to comments, and we'll just see how the time goes, Mr. Chair. If in fact it can't be done tonight, we have to come back another day. If you want me to be here, you can continue without.
I would prefer legal counsel if we continue this, I think it's a good.
Okay, so let's then, if we have no other questions, let's begin public comment. Is there anyone here that wants to provide public comment on the application? Let's get people who have not yet talked and then go from there. Go ahead.
So I'm
You have to
Jody,
state your name and your address.
sorry, I'm Jody Greer. I am Chris and Tony's daughter. I live at 164 Minnesink Avenue. I have worked, technically still work, but I worked for the Kirkwoods at the Gem and Keystone for, it's like 11 years. I love what they did with the brewery. I do appreciate what they did with the inn. And the outside buildings, like the evergreen, the cedar, all that stuff. It's beautiful. It's very nice. However, having worked there for 11 years, I know that not all of their all of their visitors are quiet. I know that they are not all necessarily respectful. And while I do not mind them, I do not mind serving them. However, there were times when I would either be walking home from work or going and visiting myself where they, how do I say this? The golfer community, would get a little rowdy in the evenings. And while they are on vacation and they are right to enjoy themselves, them staying on that direct resort property, I believe is important for the well-being of our town. I grew up in Shawnee, I still live there, I hope to live there for many, many more years. I love the town and I love the neighbors that I have, but again, it's the neighbors that make the town. The resort does not make the town. Shawnee would be just as beautiful and just as kind and just as nice, whether Shawnee Inn was there or not. It does enhance the fun because you can walk to the resort, you can walk to go golfing, you can walk to the restaurants. However, I do not necessarily believe that I want those visitors on my street or on the adjacent street, because I can see the property on Worthington, what is 133 Worthington, I can see it from my front yard. Which is fine if it was a family, it's a beautiful place to grow up. I think that everyone has a right to grow up there, and I believe that a family should be allowed to live there and raise their children there, just like the Kirkwoods are doing, because it's a beautiful town and it's a family town. And I think that taking that ability for somebody else to rent that home or own that home and raise their family here just the way we all have, I just don't think it's right to replace a family environment, a family home with a resort property. That's all I have to say.
I'd like to make a suggestion that we continue this hearing. And one of the reasons I think we should continue is this. What we've heard here is really from the applicants and from the objectors, people in the same neighborhood. You all live in the same place. Jonathan, you live there. Rob, you live there most. Okay. And there are issues here. I just got future development, outdoor activities and noise, stormwater, unique nature of neighborhood, security, and I would like the applicants to see if they could suggest some conditions that would be acceptable to the people who are dissenting here, and whether we could find some middle ground between you, because it's very difficult for us who are not neighbors there to get into something where there's real questions and also real considerations that you haven't heard until now. And your neighbors haven't been able to air until now.
Well, that's up to you.
Robert, I have a suggestion. How about we get a couple of people together from Shawnee, good people, and a couple of people are designated by the people who live there and have become a party to the case. And let them use our facility and tuck it out. It's a doable thing. It can be done. I know we're all sensible enough to know that it can be done, but it's got to be done in the right way. And as I said, I had a couple of questions myself that I didn't think I would have. So I think maybe we continue the hearing, get some people together, maybe 2 from each side, sit down in our facility if they're comfortable, and go from there. I think it could be worked out. That's all I have to say.
One other hand that was up in the room. Mike.
Public comment, and I sort of have multiple hats.
Your name, please.
Michael Albert,
Thank you.
Albert. Albert's how you spell it. It's not for you. I'm sort of a party as well, because I'm a family member. I'm also live on Worthington Street. I don't think anybody else here lives on Worthington, is that correct? So the big thing that I've heard here, I mentioned it to John. It sounds like what I'm hearing, the biggest issue is around the menacing property. I've heard John and Rob say they're 100% willing to have the conditional use be limited to the building on Worthington, which if you look at Worthington and you talk about I'm talking now.
I didn't say anything, I just stabbed myself.
So if you look at Worthington Street, it is either Kirkwood's, Albert, a few other residents, a bed and breakfast, a playhouse, and resort units and Wyndham units. That is what Worthington Street is.
I'm sorry, is this Michael?
Yeah. Hey, Brian.
How you doing? Hey, listen, there's a little bit more to it than that. You're leaving a couple of homes out of it, but go on.
Oh, no, I said there are 1, 2, 3, 4 5 other homes on the house, but everywhere south of there is, in fact, south of my house, I am 100% basically surrounded by Wyndham units, which are timeshares, not the same thing. Anyway, I'm just suggesting that the applicant has made a suggestion for a conditional use, which I think largely satisfies what a lot of people are concerned about. Obviously, probably not everything. That's all I wanted to say.
Yeah, in the interest of one last shot at concluding this tonight, would 133 Worthington being suitable as a resort use and not 177 Innocent changing at all, do enough to obviate the need for further meetings and prolonging this, or is that, I'm asking that question. 177, no change, 133 becomes a resort.
Conditional use.
That resort would be in my backyard, and so I'm consistent in being with this.
Okay.
Also opposed. There's no guarantees here. Why bother having zoning if you can use your word salad and get around it? We might as well just take this whole paper and throw it in the garbage.
With all due respect, that is, it's not how it works. I mean, they have to present an application, the burden shifts. I don't think the board is prepared to make a decision in this second, but. You know, I think other people want to speak, and our solicitor is going to be unavailable in about 90 seconds. So,
John, I have a question. Whose idea was it? And why?
Just to me?
Yeah, you spent at least $3,000 this hearing. Now, basically what we're talking about is if you have a long-term rental, rather a short-term rental. You might not make as much as a long-term rental, but it just seems this would be a lot to do about nothing. Just let it the way it is.
It just has to do with the strong demand we see for cottages, and there aren't enough of them, and it's a nice way to experience this town. And I thought it is material that Worthington Ave is already inundated with time sharing, whether we like it or not. And it's one of those things that this doesn't. My personal feelings, it doesn't change this particular building we're talking about becoming this use. Is a net positive in every way.
No, it's
Perhaps
evidently.
one house left, that can be a single family home.
These people don't feel that way, and I just, the money wise, build a cabin somewhere else on the property.
Yeah,
Use it like you've always done it, you work with good tenants there.
This is just it's a business decision. We're interested in having guests experience cottage experiences in the Shawnee. That's something that they've asked for.
Well, they might have, but it's basically gonna come down to money, how much money you make long term versus short term. And this costs you a fortune for this, I mean, it's.
This is the big guy against the little guys. Now, we don't have the resources to come here and present our case all the time. You have limitless resources. We have none. What do we have? Our voice.
Yeah. For the record, I don't have unlimited resources.
One last comment, we're gonna consider recessing this and we'll talk with those reasons availability, but go ahead, start one last.
Yeah, I mean, I'll try to be brief. Are there any lawyers in here besides, and I wanna throw out a term, stare decisis. The legal term that means let the precedent set. If you look at a map, there's a dividing line that runs right down Worthington. One side is commercial and the resort area, on the other side is residential. This proposal will carve out a little bit. I don't know if I'm kind of for it or against it. But it'll carve out a little bit of Worthington that is residential for commercial use through the leasing of the property to the Shawnee. And I
And
think
who's
that's
this? Who's that speaking?
Tony Greer.
Oh, okay. All right.
So, and I think what may happen is that'll set a precedent, right? So, you know, Shawnee and the Kirkwoods, you know, they're business people, I understand it. But the next, you know, step may be, okay, we'd like to include 177. Precedent has been set, we can make the same arguments. Decision may or may not be made in favor, I don't know. Then, you know, how about the two Benekill houses? Well, you know, we'll tear those down, we're gonna put up, you know, mixed use or.
Do they have 10 acres? You need 10 acres to have a resort use. In the
The
R1.
ones, the 133 property is not 10 acres.
133 properties is legally on the same parcel as the rest of the. It's a different address, but it's the same parcel, that's why they're here.
How is it on the same part of the parcel? If it's, you can see the parcel, it's not 10 acres.
I don't mean to, you need to like, in the interest of time,
Yeah,
we are losing our attorney. I'd like to make a motion that we continue this this hearing.
Will require that the hearing be rescheduled within 45 days.
Well,
So you should select it if you can, so you don't need to re-advertise. If you can't, then the date will have to be selected shortly and then it will be re-advertised.
We need the second and fourth Wednesday at 6, so the next one would be April 26th, with that work. Yourself.
I have it in my mind.
Yeah.
That would be. Yes, it does. I don't think I'll need to be an hour for a fifth time this fall, so we hope not.
It's April 26th, our next meeting, that work for most of you folks again.
6 P.M.
Correct.
right here at the township municipal building.
Correct. Okay, alright, so I'll entertain the Development Times motion to recess the hearing until April 26th at 6 P.M. during our regular Board of Supervisors meeting. Do I hear a second to Mr. Loveenheim's motion?
I'll second it.
Second by Mr. Barrett, any questions on that? All in favor?
Aye.
We will continue this on that date. Thank you, everybody, for being here for that part.
Let me say one thing that if in fact the applicant and some of the landowners want to get together to try to resolve this matter. I guess they can, but understand this is a hearing, so that whatever may be said or done, they not work out, and then you have to come back to the rest of the hearing, so keep that in mind.
It's not legal, if we decided to get together, it's not illegal, getting together.
Well, again, if you go there, in court, judges often say, go outside, try to settle this matter, come back and roll the hearing. That would in fact is occurring. Everyone needs to know that it may not settle. Especially with the fact that I know people don't want to hear this, a conditional use is a permitted use under the zoning law. It just is permitted with conditions, so. Leave that as it may, that'll be up to you guys to decide what you want to do.
That's with conditions.
Right,
Yep.
with condition, permitted though, with condition. Thank you. All right,
Safe travels.
Thank you, Harris.
Well, at least that's what
You're right.
Hello.
3 hours.
Oh,
Alright.
yeah.
Discussed a few minutes ago, Julie and I believe the time is now 7:40. We're going to proceed with the meeting, take the meeting beyond this used application. First order of business is the consent agenda, in which we are considering the ratification of the advertisement of the 2023 grant maintenance bid, as well as the 2023 paving bid, which is the larger contract payment. And then we're appointing additional alternates for Oak Grove and Cog, which is council governments, which is Julian Hylika and Lucas D. Bartolo, respectively, our township manager and budget and finance manager in the event that the supervisor and alternates cannot make it. Do I hear a motion on the consent agenda?
Motion to approve the consent agenda.
Okay, motion by Mr. Levinheim, I will second. Any questions? All in favor?
Aye.
Aye. Next is the consideration for the award of the spring cleanup bid to GNS Container Services, that is because they are the low bidder, they are the only bidder. And which is unfortunate, because a lot of other municipalities got other bidders. If I have it correctly, Julia, do you have the exact?
It's
No,
$1,450 a year.
alright, which is about the same more or less that we've had the last several years with inflationary increases and whatnot. The dates for spring cleanup,
Are May 17th through Saturday, May 20th.
I'm sorry, say it again.
Wednesday, May 17th through Saturday, May 20th.
yeah. Okay, so do I hear a motion to award the spring cleanup bid to GNS Container Service?
Make a motion.
Motion by
I'll
Mr.
second it.
Lowe,
I'll second it.
second by Mr. Barrett, any questions? All in favor?
Aye.
Aye. Next is a proposal put forward by the budget and finance manager with regard to the spring cleanup fee schedule. In the past, it has been very low, but the burden has largely fallen on independent taxpayers. The single family residents and whatnot, as opposed to some of the larger users of this, which are like the dump trucks and whatnot. The proposal contemplates a minimal change, but it's based upon research from the Poobah, Pocono, Stroud, and Middle Smithfield Township cleanup. So Lucas proposes mostly changes on that round, which are for the utility trailer 2-axle, which should be $75, which is roughly twice what it is now. And it essentially keeps flat the single item fee, which is nothing, and then the cars are also $15. So minimal change there, but this will help us recoup more of our costs. And it's probably the biggest public service that we provide. And we also are not doing Sunday this year because we have not had nearly as many individuals utilize it there. So, board, I know that you have had Lucas's proposal in your inbox. Do you have any thoughts on that? While we're discussing it.
I think we should move to approve it.
Okay.
I agree.
Ryan,
Yeah.
ready to approve the new fee schedule?
Yeah, I looked it over and then we're in line with most other areas. So yeah, definitely I approve it.
Okay, motion from Mr. Barrett, do I hear a second? Second, Mr. Levenheim, any questions? All in favor?
Aye.
Aye. Next is an item introduced by Mr. Levenheim, which is to award a contract for the Waterfront Park House capital improvement study as approved in our budget.
I'd like to address that.
Okay, well, you can address it when the board is done considering it, so you can address.
Well, I don't want to
You can, well, you can hold on until we're done with the discussion, and then you can talk about it before we would vote. And the standard rules of public comment.
get down here.
Okay. Robert, do you wanna discuss this?
Yeah, I'll discuss it for a minute. We had two bids. The first one is by a company that, I don't think we should do business with, which is, what is it, Vanderhoff and
Schooner?
Schooner and Vanderhoff. They came out, Ray Vanderhoff.
Wayne.
We didn't hear from him for a month. He didn't respond to emails. Finally, we got a proposal sent by his secretary. And then wrote back and saying, what took a month to give us this, and it's pretty skimpy. I never heard from them. Ray O'Brien is an architect in Blairstown, and he specializes in these kinds of remodels. He's doing one now for Franklin Township in New Jersey. He's doing one for Portland Rural and Pennsylvania. He also did a building in Haynesburg, I think it is, abandoned mansion, very similar. Came out, looked around, had some very good ideas, gave the proposal within 24 hours. I think he's our man. So I would make a motion that we award the contract for the waterfront park house capital improvement study to O'Brien Architects.
When do I get to that?
After the board seconds it, and we can give our discussion, then you can speak before we call the vote. So I'll second that for the purposes of discussion, but Robert, do you want to discuss the impetus for
What?
this, the impetus for the
The impetus is
park?
both
Boy Scouts?
that we've really come to the conclusion that the house should be renovated rather than trying to build a new facility. It has at least 2 or 3 good rooms downstairs.
Take your time. I know.
Also, we have a guaranteed tenant that we move in, which is the sewer authority. So, I'm hoping that, when the figures come out, we can somehow, use the rental from the sewer authority as at least, getting started on some of the renovations.
Robert, before I vote, why did you dismiss Vanderhoof and his firm?
I dismissed them because they were not responsive at all. They met with Russ, Albert, and I over a month ago. I heard nothing. I then emailed, I heard nothing. Last Friday, I think it was, Thursday, I finally got a proposal. It was sent by his secretary, not even by him. I then wrote back and saying, why didn't we hear from him? And why it took a month? And why was this so skimpy? Because it really was saying almost nothing. I never got an answer. My feeling is I don't want to deal with somebody like that.
Oh, that's your feeling. Okay, and you vote that way. I'm just thinking, there's a guy who spent so much. He was a supervisor. He did it for free. He didn't do it for money. He's a good architect. I'm surprised that you, I don't know, you guys had knit her off, I guess. But having said that, why didn't we advertise it?
Why did what?
Why you put it over there after?
It's
Yeah.
only, if we're talking about $2,500 to $3,500, it's not something we did.
Robert.
There are very few good architects around that can do this. O'Brien is one of them, and I'm surprised that it's Schooner Vanderhoff too. But I can only tell you the experience was very disappointing. Let's call it that, okay? And I, for one, wouldn't deal with a mechanic.
Why don't you have to deal with him?
Well, maybe so, but you know something? I'm the guy that's in charge of it, okay?
Hey, you're wasting our money there, $3,500.
Yeah.
I still think, here we go. That kind of money, we should have advertised it.
For $3,500,
Professional service is not required.
It's $3,500.
there's a motion on the table.
That allows us to spend a fortune. I don't know. Those people are familiar with it. They've done work in the pro bono work on the house, kept it going, kept it safe.
You may know this firm when they built this building, but I don't know what this firm is today. I can only tell you my experience, and it wasn't good.
Okay, I'm gonna remind everybody that when we're discussing individual items, the comments are to be germane to that item, so if you wanna address some things. Do that.
What's that? What did you say, Jacob?
That comment during an agenda item must be germane to that agenda item. And if you have other things to address, you can do so in the typical public comment or. Well, yes, at that point, or if you're a supervisor in the board of supervisors.
Oh, both, so I don't have to stand here forever. I know you
Okay,
got all-
anyway, I don't know where you're going. Did, Robert vote? Did you vote, Jacob?
I didn't know, he just, there was a motion and a second, we were still discussing, and I was listening to what people had to say.
Okay, well, do you second it?
I seconded it for the purposes of the discussion, second is only that.
Now,
I'm still contemplating, I'd like a minute just to think about this. I mean, I do appreciate that, both were reached out to, I suppose. I mean, I think that the key is the study is necessary regardless of who it goes for, because we need to do things to improve that building.
I agree with that. You know, he never said, but no, you don't
All right, hey,
No. But can I go and talk?
I
was a very confident gentleman in this.
I'm the one who researched this. I'm the one who's gone into that building with both architects. My feeling is this is the guy that should do it, and also the guy who's very competent to do it. I have no faith in the other one based on
And I have no faith in you as a supervisor. I think you should resign.
Hold on,
I said, if you win the election,
where do we stand?
hold on, all right, all in favor of the motion? Say aye.
aye.
Aye. Opposed?
Opposed?
Okay.
Jacob, I'm surprised, man. I'm surprised. All right, Jacob. Enough is enough. This is, all right. What?
You?
I
Just,
can't hear you.
you vote, Ryan, can you still hear us? Ryan? Okay.
Let's move on to the
Moving on to
airstrip
the
road
airstrip
comment.
You just talked.
Yeah.
You know, he sent a very nasty letter, and all through this building, Wayne Vanderbilt. What he said as chairman of the board where you were sitting, he was a gentleman, a professional. He only took $200 a month, not like you two. He knows what he's doing, been in and out of that house, I've been in and out. This is another one, it's complete waste of money. I believe John Presley's been there, Ken's been through there, Gino's been through there. He just, this one is. It was $1,000 each to appraise those lots over, so they found out, which one, if they had no intention of selling, he's not gonna talk to you. And like that, they're just, but you don't know that yet, but
You become supervisor, you can do whatever you want as far as the cost goes.
Can we please be respectful here?
he's not.
I'm not referring to you, Robert.
He took a prominent number. He sent out a salty letter.
I think we're probably familiar with that thing, so we're gonna move on to the next item.
You don't have any balls, do you?
Excuse me. I think that, this is a perfect display that the voters should say.
I agree, I think they should see all my this, but this is
And
letter.
if they want more of you, they should vote for you.
Well, you have to tell me you're gonna blow a complex, not marriage.
Not go on.
You told me you're gonna blow a complex.
If you want to address this, you can address it.
I have nothing to do with Mountain Manor until it's sold to somebody.
You can, hold on, you can address.
You're a sad sick old man.
All right, Pam. We don't need this.
Speak there, it's not worth it.
We don't need this. Let's move forward. Okay, the next item is the consideration of the airstrip road condemnation resolution. And we're going to move to table this because the other party, which is the Industrial Development Authority, which is the agent for the proposed taking. They are not here this evening, so they have requested that we table it because they had some technical changes, and that was a proposal to take a portion of the road right away in order to add a water main to connect to the industrial buildings there. Just for normalcy's sake, so I move that we table this item.
Second.
Motion by myself, second by Mr. Levin. Any questions? All in favor?
Aye.
Aye. Next is a discussion about Rivers Edge Bike Park. We have a proposal from Level Engineering. John, would you like to address this?
Sure. Would be,
Just for those of you that haven't been to our meeting before, I apologize on behalf of.
Well,
The
this stuff
township
happens
for-
at local meetings far and wide across the
It's not happens, but
country.
you're not always as racist, bigoted, or deplorable as Mrs. Barrett. And I have over 250 emails from this woman dating back 4 years and more of that. So when she references bad letters, you know, it's the pie calling the kettle black, but he would have a problem with that too.
And I'm so sorry, but she was talking to me about something when you were talking about Act 167, and that was one of the reasons I stayed. Can you tell me what that was briefly? We are just getting into that right now.
Oh,
Oh,
I accidentally skipped that.
okay.
Okay, you can address, I'm sorry. I was not off balance, I'm sorry.
okay, so
Act 167.
you want me to address that?
Yeah, sure.
I'm not sure what you want me to say, other than, probably what you already know, and I can address the audience. The Monroe County is in the process of updating Act 167. Act 167 is the Stormwater Management Act. And part of that act, the purpose of the act is to adopt a program along with ordinances, so that when a piece of property is developed, the runoff coming off that property is no greater after development than prior to development. And the obvious intent is to protect downstream property owners from increased rates of runoff. There currently is a Act 167 plan in place right now. I think the township adopted it back in 2006 or thereabouts. The DEP, they've got legislation that says it should be updated every 5 years. No one pays attention to that. About half the state hasn't even adopted one yet. That's just some background information, not really pertinent to what's happening today. Most recently, the County Conservation District was charged with updating the plan, and they circulated a model ordinance to the various townships within the county for comment, hoping that the board would adopt their model ordinance. There has been some controversy with the ordinance. There have been some positive changes, in my opinion, as an engineer. I think they streamlined the process for some smaller projects. It's not quite as cumbersome. But there's two changes that have been proposed that has generated a lot of comment from several of the townships. There never used to be any buffers around lakes and ponds. They have now inserted a 150-foot buffer, which pretty much doesn't allow any activity within those buffers. It's more strict than the ones that are currently around wetlands and streams and rivers. And they also have suggested a provision that the Board of Supervisors, in this case, could no longer waive activities in those buffers if an applicant wanted to do something within that buffer, they would have to go to the zoning hearing board to seek a variance, which is one more level. So that's my summary. What's before you, I can tell you, and I think I may have said it, but I think it's worth repeating because I've received a lot of emails, I'm sure maybe the rest of you have, where some townships are balking at the idea that they should give up their authority as the governing body to the zoning hearing board on the buffer issue.
That's my exact question, and I know that you know Taylor Munoz very well by this point, and I know that he and I have expressed that same concern with some of the other municipalities. There's only one that I know of that believes this is it imposed a reduction to the private townships, their buffers are 300 feet already. But Pocono and us in Middle Smithfield, I know are very concerned because there's very limited room for.
Right, and I will tell you, and I did some research at Taylor's request. This was handed down from the DEP to the Conservation District to prepare this ordinance, this model ordinance. The DEP itself has a model ordinance. They have no buffers. They've got a 35-foot buffer around the street, and that's it. So the Conservation District has come up with these ideas on their own. I'm not here to say whether they're good ideas or bad ideas, that's for the governing body to determine, but they come up with them on their own. They can't point to the state, and they try to infer that, but that's not the case.
They tried to infer that there would be no more funding.
Right, well, there's no funding anywhere. That's why I have to say it doesn't have an Act 167 right now. So that's what I can tell you.
Well, I know that we also have MS4 requirements, which for those of you who don't know, the municipal separate stormwater system, which deals with runoff and other larger parcels and whatnot, like the Smithfield Gateway project and things like that. And that also has its own requirements, and it's really only for what they classify as like urbanized townships. So Smithfield Township falls into that, as does, I think, Pocono also.
Pocono definitely does. I think it's based on population.
Right, so we have to sort of marry those two requirements. Does the DEP model ordinance match more of?
But yeah, I mean, Missy's been doing your MS4 before.
Yeah.
But you're in compliance.
Right.
And the DEP model ordinance doesn't have anything in it that would be any different than what you already have.
Okay.
I even discussed with, I don't know what they're gonna do. I saw Taylor put out an email today.
Yeah.
I'm not sure how that board's gonna react. There was some discussion. Maybe we'll take a look at the DEP model ordinance as opposed to the county, so.
Yeah, I'd love to do that, because I don't, our requirements here are already relatively strict. And
And what are they? Because I thought we did have 150 buffers around everything already.
No, you do have them around wetlands. And we do have them along the streams and rivers. So, but what they've added,
Yeah, what is the thought to not have it around ponds or lakes?
well, they just remember there, DEP does not require.
Yeah, so I was around when this went through in 2006 and
Yeah.
this, obviously part of our PRD settlement has in some places 300-foot buffers. And that was when all that discussion was going around. And so I'm not as up to date on the research and the benefits now, like it's not front of mind anymore. That was a long time ago,
Right.
17 years ago. But 35 buffers, 35 feet is certainly not sufficient. And I would argue that, 100, 150 minimum should be the goal.
I think that there's a lot, I don't disagree with
And
that.
I respect what you're saying, however, one of the things that Taylor asked,
And who was Taylor?
Taylor, he's the township manager for Pocono Township. But there's 99 people on this email, all the townships, so that's why I feel free to
Yes.
express
No, I didn't
this.
know who that was.
But we asked, through Taylor, we asked the Conservation District. What's the rationale for 50 foot? What's the rationale for 150? What's the rationale for 300 foot?
Yeah, well, there is literature on that.
Well, we got no answer.
See, they didn't provide.
That they provided, no.
There's also questions, which I don't know how everyone feels about this, but there's a question as, to well, one, my main opposition to the portion of the model ordinance from the conservation district is that it would take it away from the elected officials and make
Yeah,
it
I have
appointed
to kind of
officials.
support that, because you never know who's gonna be in your.
Hey, oh, believe me.
If they're needed, and people shouldn't be able to wait on this, how I feel about that.
Well, so there's the disturbance area, then there's like the protected area, so you can have limited encroachment, but there are like firm guidelines within some. There's another question though as to, I think, people. But they consider the ponds, sometimes if they're man-made, don't they consider them natural features?
Well, they do, and that just comes down to a court decision which came down today at the federal level.
Oh.
But to get back to your point. I don't know how big a property you own, but let's say you own a 150-foot wide piece of property, it's a legal lot within the township, within the zoning district. Right next door to you, off of your property. Somebody has a pond. And you said you don't think there should be any relief. This property was given to you 10 years ago by your
Right.
parents for you to build a house. No relief, you can't build because you're in that buffer.
Right,
And that's not on, I don't think that's fair
right.
personally. That's not my professional opinion. I don't think it's fair
Right.
personally to, property owners. But that's exactly how
I was gonna say, I'm sorry, that maybe it should be over a certain parcel size or something, I don't know, I mean, I think you guys are pretty good at finding, you know.
Yeah, I mean, honestly, what we have right now is pretty solid. There could be some areas where it might need something.
And I can tell you, as long as I've been here, there have been developers who have come in and asked for relief. And in some cases it has been, but not, I mean, it just wasn't handed out like candy. I mean, they took a very hard look at those applications. As an engineer, I will speak. I can see some buffers on the uphill side of the stream where you, if you've got development up above that and you've got some polluted water coming down, yes, it's nice to have a buffer to protect things. But what does a buffer 150 feet long on the downhill side of a pond, what purpose does that serve? Now, maybe it's a purpose. We asked the conservation district to tell us. They had no answer. So there's a lot to consider.
Yeah, I see what you're saying, I mean, no.
Yeah, I mean, I certainly am sympathetic to what you're saying, because certainly, I consider myself an environmentalist, and I don't wanna see, the environment deteriorated by development. And at the same time, I think it's possible to make sure that we have matured requirements that make sense.
Yes,
A lot-
not an undue burden, like you're saying, like I get that point you brought up.
Yeah, and a lot of the waivers that we've granted in the past, in particular with like the impervious surface and whatnot. Have been like the Trapasso self-storage.
Right.
And the grants on the waivers there were not necessarily. So they could follow a looser guideline, it was actually a stricter one, but our ordinance required something that was substandard. I think according to, was it? I forget, well, detention basins, they wanted
That's how you calculate the runoff rates. Our ordinance remains substandard to what you have to do for the conservation district. Now, that's the one positive about this change in the Act 167. It does, if the model ordinance is adopted, and I think parts of it should be, that would make that waiver no longer necessary because everything would be now harmonized.
right,
So there's good aspects to it, but. And again, there's
Well, it's a template, it's a model, right, so you can tweak it.
yes,
Yeah.
and there's pockets all over. We have a development, somebody wants to develop something in Pocono Township, they want to develop, it's gonna be a wild one, it's not a secret. And there's a little patch of wetlands about a quarter the size of this room. It serves no useful purpose, it's because the whole site is flat. And this developed a depression over time because a lot of cars would be parked there and stuff. So now it traps water. Now it's
meets the definition of a wetland. You could develop that parcel if the board didn't tell them that, yes, we're not concerned with that. So I suppose you could get, hopefully, with clear minds, you could get the same result by going to the zoning hearing board and claiming it was a hardship. But you're asking your residents, your business people in the township to jump through one more hoop, when really the elected officials are probably the ones who be making those types of decisions.
Forgive me if I'm wrong, because we haven't had many variances, but generally, those are not always reviewed by the planning commission. You know, there's very few cases where they haven't, because I know there are like 3 or 4 types of variances that only the board is, the board of supervisors can hear, but in this case, like the planning commission wouldn't hear all of these things. I mean, I like the thoughtful process that we have now. I mean, there are some times it seems to avoid any thought, but I think that, I'd like to see if we can marry the 2 model ordinances, because I think there's something better than what they're suggesting, and you know, I think that's what the issue is. The conservation district seems insistent that everyone have the model ordinance, and that they don't actually use it as a model that you can, you know, put in different, you know, puzzle pieces that are unique to like Price Township, that entirely different animal than us, we feel we want to have different requirements than them.
And that's the whole purpose of a model ordinance. This is where you start.
I think we got off on the wrong foot with them because they said that there was gonna be funding in jeopardy if that did not get adopted by May 1st, when not all of us were involved in the process. And we were to some extent, but it could have been better. I think they did better on some of the other countywide plans, but that's the hope. So I guess at this point, all we can really do is compare the 2 and we can talk about it with the plan.
Yeah, Taylor asked me. I gotta get moving, get busy. He asked me to come up with recommended changes. That's their next step.
Right. So I believe that his intention with that, and I didn't talk to him about this particular portion, but I know that a number of individuals at COG representing other municipalities all have the same type of concern, so I could see maybe you get to come to one of those meetings and press everybody, because I think it's a pretty big concern among those that attend.
Yeah, I'll be happy to.
Let's,
Yeah,
move on.
okay. Yeah, all right, let's talk about River's Edge Bike Park. Smithfield approved, you know, their half of this proposal.
Is this cash we're putting out, or is this grant?
This will be cash. This proposal relates to, Level Engineering Group doing the study at River's Edge Bike Park to determine how badly it is screwed up, so we can fix it.
So it's about $14,000.
It's just under $14,000.
But beyond that, Julia, we're also going to give you a permit and put it out there.
Do all of the bidding, you know, soup to nuts with them.
So
We met.
Supervisor, manager.
As township manager, I met with Smithfield Township on the 31st. They said we're good to go as long as we're good to go. So it is in front of you now. If you approve it, we'll get started on this and make sure that we hit our deadline with our NPDES permit that expires.
I'll make a motion to approve.
Motion by Mr. Levin and second by myself. Any questions? All in favor?
Aye.
Aye. Okay, next is a discussion on the EDC grant application and.
What is this TBDC?
I always get them, Pennsylvania Development Disabilities Council. This is the grant that you
Right.
had brought to my attention, wanted to bring it to the board before I willy-nilly applied for anything. Robert is interested in pursuing musical instruments over for Waterfront Park for one of our site pods. It's a grant that we can apply for.
Yeah, let's see, how much is it, 15,000?
I have not had the opportunity to read through everything yet. It is a 63 pages of stuff and it's due on May 1st.
All right, well,
So this will put me under a little bit of stress to get done, but I wanted to make sure that it was okay that I applied for this.
since we have a park that is specifically tailored for people with disabilities, I think it should be something they would be interested in.
Yeah.
I prepared this today just for both of you. Just to give an idea. My feeling is finishing everything that we're not currently budgeted for under the LSA grant. It's probably somewhere under $10,000, and the musical instruments themselves are only about less than $5,000 for all of this stuff. But then there's questions of, well, I can't answer this. I sent it to Melissa too. How much will it cost to put some, what do they call it? Some kind of flooring around these sorts of sculptures that works for children and cushioning them from fall rays. There's special, there are tiles that go in there. If you want to see something that is an elaborate use of them, go up to Mountain View Park across from Barley Creek.
Yeah.
They use them. I think we only need small areas around the sculptures, but that's an expense. At some point, we're gonna need a sign that says, what this whole thing is. That's probably around $1,000 once you get through with the sign. Somebody designing what's on it and installing it. So I came up figuring out, $10,000. And if we could get that from this Disabilities Act, it would be wonderful.
Does it require an extra?
I haven't read through,
Okay.
but, if it does require a match, I'll come back.
I think there is a
Any
match.
information.
I think there's a match, but it may be an in-kind match, I can't remember. I read through it.
I'll look into it
Agreed.
as soon as I can comment on the board, because we're
Very well.
very impressed with this.
I'll make a motion that we apply for the grant.
Motion by Mr. Levenheim, second by myself. Any questions? All in favor? Aye. I'd be remiss, do you mind if I divert a little bit? Is there a particular agenda item you want to do? I feel you're the most fantastic audience members ever at a municipal meeting.
There is definitely an agenda item we would like to discuss. I don't know if the gentleman over here has one as well, but I'd be happy to chat with you because you guys are great. You've been patient and we want to test it a little further.
Let's,
Is that okay?
Sure.
move it. State your name, sir.
Yes, I'm Rob Tutoriello. My wife Lisa, this is my neighbor Kermit Chamberlain. His wife Marge is not here today. She's recovering from a surgery. You've been very patient with your audience tonight. I'm going to test it a little further. I have a written statement that's going to take about 4 minutes to read to give you a 6-year synopsis of what we've experienced. We're here today representing 2 of 3 properties that exist on Raynor Lane in Stroudsburg, Smithfield Township. We would like to bring your attention in the most emphatic way to witness and experience the longstanding issues regarding a third adjacent property with whom we share an access road and property lines. Raynor Lane is a dead-end 200-foot long strip of asphalt, absent street sign or mail service. It drops perpendicularly into the woods off Route 611. It allows access to only the 3 properties. There's a deeded but non-existent 50-foot wide cul-de-sac at the bottom. One of the 2 properties represented here today, number 5, is owned by Mr. Chamberlain and his wife Marge, who is not here. They have lived on Raynor Lane peacefully since 1978 and would like to continue to do so. Clearly, as retirees, they deserve to be allowed to do so. The second property represented here today is number 15, owned by my wife Lisa and I. My name is Rob Tutoriello. We bought our home in 2014 and have been happy to call it home. It's a beautiful peaceful place among nature. Especially important for me, I survived a cancerous tumor in my head. I closed my business after 25 years. It has been my sanctuary. Our property is at the end of Raynor Lane, 6.97 acres of natural beauty. It's got 400-foot frontage on Cherry Creek and view of the Gap. It's kissed by the sun all day. Everything grows in our river basin microclimate yard. We appreciate that for whatever reason, the topography, waterway or highway, it's truly a special place, as full of nature as anyone could imagine. All manner of wildlife funnel through and grace our backyard. Anyone who visits the street does some kind of seasonal show courtesy of Mother Nature. The point to my sharing all this with you is to establish what the baseline was recently for the R1 zone property and area. When we moved in, we were very pleased to meet the Chamberlains and had maintained a friendship. At that time, a third family on Raynor Lane, number 6, unfortunately hit some hard times and the property fell into foreclosure. When the property was ultimately sold in 2017, we met the family who would become our neighbors. And sadly, as property owners in the beauty of Cherry Valley, our worst nightmares. There is a large extended family that randomly occupies number 6 these days. The property is in the name of a young adult daughter, Marlena Buna, but her father, Gregory, is clearly in charge. It is with regard to this third property, number 6, that we're here today, seeking to escalate awareness of a situation that has deteriorated to our absolute frustration and dismay. What had been a third home on our quiet R1 zone, tree-lined, ridiculous and private Raynor Lane, that home with a 2-car garage and a basketball hoop and a lawnmower, became an industrial dump site as if it was in Lodi, New Jersey. It has become the exact opposite of R1 zoning. In the beginning, all was friendly with the new neighbors. A new family was going to fix up an old house. Great. The new neighbors came out only on the weekends, and I thought it was a nice gesture to plow their driveway into winter when it snowed. Good neighbor policy, animal. We expected that the new neighbors would simply be fixing up the home as they were always industriously busy in DIY mode, installing a new roof, new windows. We assumed that eventually they would be done and peace and quiet would return. However, things began to devolve and accumulate. Nothing was ever complete, in spite of the fact that there's a constant churn of doing things at the property. This constant churn has been a 6-year front row seat to activity that should not be allowed for our zoning on their limited acreage. Your zoning ordinance, types of uses compatible with the natural environment. Several years ago, our neighbors installed a large unwalled tin storage roof, about 25 foot square, bolted onto the original 2-car garage. It was constantly overflowing, materials being stored. That mess of a building sat there for years, greeting us daily. The tin roof collapsed in the snow a few years later and was patched together, remaining an even worse eyesore of industry on a shared private road. For some time now, this neighboring property has been the source of anger, frustration, and anxiety, as almost any time we come home from simply running an errand on the weekend, we never know what fresh hell we're going to be returning to courtesy of next door. It has been a source of sleepless nights and arguments. One day, as I engaged the patriarch, Gregory, in a dialogue asking how much longer was it going to go on, he proudly gave me a tour of the place, inviting me into the home, showing me what had been done. It was far from complete. I've been in hunting camps that were in better shape. Then he showed me the office space with desks above the garage from where he would, quote, run his business. And then he showed me plans for a 30 by 30 3-bay garage, in addition to the 2 that were there and the 3rd that had been built. So now we have 6 garage bays on a little strip of nothing. And he was excited that he was going to build this garage bay 75 feet off our bedroom window and would have been a piece of quiet in the woods. Mind you, there are car lifts, bandsaws, arc welders, plumbing supplies, old fans, windows, debris, scaffolding, lumber, concrete, foundation molds. He is in the construction business. They run a window replacement weatherproofing company in Manhattan, yet the property is owned by his daughter. He is not a resident. He's making the life of a year-round tax-paying resident absolutely miserable. I have not even mentioned the fact that this abuse of our neighboring property is made all the more maddening by the fact that my wife and I only recently returned to our home after being displaced for 3 years for a house fire. Since 2020, we've been vagabonds renting nearby while we rebuilt our home. A tree crushed our attic during the storm, causing an electrical fire, and this was all during the pandemic when construction was shut down and the supply chain was an issue everywhere. We finally got home and were greeted by this crowd line. We put a good amount of personal money into our rebuild beyond insurance, only to watch the potential value of our property decline with every new addition to the neighbor's menagerie of industry and debris. For the rebuild, we now have a spray foam insulated home, but we can still hear the backhoe and loader all day Saturday and Sunday as they dig a foundation for what will be this 30 by 30 2-story building. His words, he's digging out a mountain, he's carving it down, he has a permit for a 990 square foot building, and he showed me, look at the trap door where I keep all my supplies, and I can go down 2 stories. This is happening on a hill, right outside my bedroom.
Let me stop here. I just want to ask a question.
Please.
You're off of 611.
Yes.
So is it kind of past the bus station?
Do you know where Titani's at the top of the hill?
Yeah.
And March Station at the bottom.
Right.
As you come down, there's a little spit called Briarcliff, and there are 2 stone bears there. Then there's a power cut. And then there's nothing that goes into the woods. That's our house. That's all it is.
Yeah, they call it, yeah.
Okay.
Have you contacted the zoning office?
I've spoken to Ken Wolf, and I will go on and explain to you that Ken was really helpful, but then told me,
Well,
they have a permit for the 900. When we saw the permit, our heads exploded. So
well, I think it needs further discussion with.
Thank you, sir.
What we can do. Unfortunately, he's going on vacation, I think, for the next couple of weeks.
Well, they're pouring concrete in about 2 weeks.
Huh?
They're pouring concrete in about 2 weeks.
Well, yeah, the zoning officer, we could, I mean, I'm gonna let you finish your thing.
Thank you.
But, before that, we could probably also talk to the conservation district, because it sounds like there's earth moving and other different things, but please proceed with it.
Thank you. Okay, so we have, it's a 2-story building, frequently find we can't even open up the windows in our own country home because all we smell are diesel fumes and your construction noise. I understand DIY. I mow my lawn, Kermit, here's my leaf blower. That's the sounds of homeownership in the country, not what we experience, not by far. Last year, Kermit and I engaged a lawyer to seek guidance as the situation became untenable. We personally presented a letter from our attorney to the Patriarch Gregory in June. We had to meander through a less than 3-acre property to find him due to the labyrinth of machinery, vehicles, and trailers present on that particular day. After our dialogue, they promptly moved a lot of that overt mess and the tin roof to the other side of the home, where it still resides. Problem solved, right? I contacted Ken Wolf to tell him of this ridiculousness. Ken, to his credit, even visited the property on a Sunday at my behest because it's only weekend warrior stuff. Upon finding the Patriarch Gregory working, Ken was assured that the activity on site was only personal in nature. And that lie has allowed the lives of the Chamberlains and my family to be thrown into permanent chaos, bringing us here to talk to you today. Almost every weekend, there are 2 to 4 white transit vans or Ford Econoline vans that arrive. There are always different cars and trailers that pull in. Since 2017, there are always people working on or at the house, but they are never finished. I just had our shared property line surveyed, and there are boats on trailers and piles of gravel and many glass windows being stored leaning against the trees in what is that deeded cul-de-sac, all visible from my dining room windows since we chose to cut down so many trees. They even had a company sign nailed to the building for about a year until we called them out on it and they promptly took it down. I've not even mentioned the chickens that stroll down my driveway, causing my 150-pound dog to pull my wife like a rag doll. There is an absolute lack of consideration by this group of people for the very serious impact they have on anyone else remotely near them. They are mere feet away in what used to be an amazing place, and all but the adult daughter are guests ruining the lives of residents. These problems have to be resolved. It is impossible to believe that this type of independence is allowed by non-residents, even as it tramples the rights of those who might have been here for decades and simply seek to buy into our own zoning in the country. We are hoping that you, the supervisory board, might bring some sanity to this runaway train of zoning abuse. After that, we're investigating all means to attenuate a bad situation. It must also be pointed out that if allowed, the presence of 6 garage bays on the number 6 property combined with the existing issues of Raynor Lane will result in both increased traffic and potential for vehicular collision. Sometimes named the street again. Raynor, R-A-Y-N-O-R, as Kirby can tell you, named after Raymond and Norma, from whom I believe you bought your property in 78. Correct. Ray Roberts. Sometimes getting off and on 611 is a challenge, especially on weekends. Cars traveling south on 611 coming down from Titani are doing 60 miles an hour, and Raynor Lane is a small unmarked strip of asphalt in the middle of the woods. Our lives have been made more challenging by the allowance of those garage bays and the resulting, no doubt, additional vehicular traffic. I've come across, and all of a sudden there's somebody coming up, and the sight lines are limited, there's a dip, there's a hill, and now I have all kinds of traffic that we never used to have before. I know 35 miles an hour. It's, well, nobody does that. Down by the bus station. Yeah, I actually use a 45-mile-an-hour street sign that we tell people at 45-mile-an-hour sound is our law. Right. If I knew now that the current situation number 6 existed when I was looking to purchase a property as beautiful as it is behind my fence, I would have never bought this house with the sideshow industrial site garbage dump next door. If left unchecked, the situation will cost money in the future for the continued loss of property value and the abuse of R1 zoning. So if necessary, action through the court may be required. However, we hope that won't be necessary for the obviousness of the zoning abuses we've shared with you tonight. Thank you in advance for your time and attention to what remains for us a very serious situation.
Thank you for staying 2.5 hours there.
Thank you for listening.
Yeah, absolutely.
I really were upset about this.
Yeah, there's a number of things that we can, look into. I mean, I think number one, the conservation district's important because of the nature of some of those things, with excavation and whatnot, but also to Robert's point, our zoning officer can file citations presumably for some of those things, and that will be up to the district judge.
I have the permit number because he showed us proudly. Here's my permit. See, it's all good.
And
But it was for 900, not first of all, there's a building, then there's 3 garages, then 3 more. Isn't there a variance of accessory building to residence building that they have trampled somehow? It's not that big a house.
This is what I'd like to do. I can't do this to the beginning of the week, but I'd like to come out and just.
I would love to have you, I'll make you hot coffee.
I will. I won't, I may not contact you. I'll just cruise around, see what it looks like. It's hard to imagine.
Go to the power cut and look down.
They're up against the power.
They're on the power cut with the foundational mold elements for the hole that it's come on the weekends, it's really a party.
Well, I probably hit there on Monday or Tuesday.
No, I understand, I appreciate that. This weekend was quiet, I just.
You get both get shot at the same time, that would be good.
And
Maybe
maybe
I
I
should
should
just get something.
When you're back, I can email it to you, if that's okay. Is it, I scribbled notes on. Thank you.
And if you need me, it's just.
When I purchased the property,
Yeah,
that's
Smithfield.com.
it's Robert,
Yeah.
I had to have my house approved by Ray Roberts, who was a real estate man. I don't, you're too young to know Ray Roberts.
It's familiar, I think it's very.
Country Cousins, Country Cousins had his business. He owned the old stone house on Cherry Valley, that was Ray's house.
Yeah.
And his idea was that he was going to retire and move out of the stone house and property that Rob and Lisa owned. His house was gonna be up further than where, from what he told me, shared with me. But he was so precise about my buying the property and my intent on the property. I had to have my house approved. I wanted to put a woodshed up at some point in time, and he had to have that was drawn in the plans. I could not cut any trees down 30 feet from my property line. Because he established this property, the 6 acres that he owned, that they own, the 1.8 that I own, and the 2 point something that. 2.4, I think. Yeah, that my original neighbor was, people call Colstead. He was an architect, he designed a house, he was from New York, he designed a house, built a garage, lived in the garage, and then he and 5 people framed his house out. His wife came up from New York and they lived there for about 15 years until they separated. And then things went downhill. And they went downhill, not as much as they are now. But my point is, there was some idea of this property that he and Ray Roberts owned and what he wanted it to be. And I don't think he envisioned a piece of property that's gonna be commercial, as far as we're concerned. Now, he assured me he wasn't gonna have a commercial business. But The evidence is that. I know that Rob has had some trucks down there because he's trying to replace the stuff that burned in his house.
Sure.
But today it was a big panel truck that came down and made a delivery. Last week there was a big trailer truck that came down and made a delivery to their place. I don't know what they're bringing out of it, but obviously, you know, to me, he's building that three bay garage to have cellars for some purpose.
Well,
And he doesn't own the property.
take a look at it,
I
because
appreciate
it's
it.
hard to visualize just here.
I have lots of photos. And the gas, you know, like they smell the gas and that from the diesel, all and all that. My wife was out yesterday for the first time in a long time walking around. She asked me, she went down to the corner where their driveway is. And she asked me, when you were there, did you smell gas? Well, I'm all stuffed up with allergies and this time of year. I didn't, but she complained about the gas, you know, smell that she smelled. And it's constant. I mean, this is going on for years.
That's why we approve.
You know, how long are they gonna build? So mine didn't take that long to build. And we built it from scratch. And they've been working on it, and I'm telling, look, these guys obviously work hard. You know, and they're nice when you talk to them, but there's something about it that just rubs me the wrong way.
Well, it impairs your, you know, reasonable right to defend your own property. So.
Right.
By a lot, and those people don't even live there.
Okay, but first step, we'll take a look. Then we'll talk more about it.
Thank you, I appreciate it, I will be in touch with you, I have your phone number, but you're gonna give me a card with an email
Yeah, if you want
address.
to send them the pictures and stuff, and that way we can
I'll forward it on,
look at that as well.
There's my email and then Robertson's on that.
Thank you.
We also have 2 boats, big boats, sailboat.
So,
And according to him, his brother, whoever his brother is, and I wouldn't, they just put the sale up. They make it on your creek.
I thank you very
I
much.
appreciate your patience. You guys have had a long evening and some of it's been very tough.
Yeah, thanks, Richard.
But I gotta tell you, it's entertaining. It is a learning experience for us. So thank you. We appreciate you.
Absolutely, thank you.
Come be in touch. Chat meet then.
Oh, yeah.
Yeah, I see it's entertaining. Water gas. Yeah. Thank you very much.
I'd like to postpone the discussion of non-governmental contributions. Some questions about.
Yeah, I think at this point, we're getting past.
It's 8:30.
We're getting down, so the point of being rational.
I would like to point out one thing, if I may.
Sure.
You skipped over number 7, plans to act on. And that's.
You are correct.
Now, they have made a new submittal,
Oh,
and we checked with their engineer. You gave this plan final approval back in 2020.
Yeah.
right.
They have resubmitted with changes. We believe that it has to go through the process again.
Yeah, if you have a final approval.
So I would recommend that, and they came in on the 23rd, so the clock's already ticking, 23rd of February. So I would recommend that the Board of Supervisors recommend this, refer this to the Planning Commission for review and comment.
How different is it?
I don't know because I didn't get into it, but I asked, because we just found out, we thought they were just addressing, there were a couple outstanding comments on our previous approval. We thought that's all they were addressing. I asked Smithy to call their engineer. First of all, it's a brand new engineer.
No, it's not right, too.
No, and he said they changed the driveway and did some other things. And they said they've done all new stormwater calculations. They said we have to get a new MPDS permit for this updated.
That seems substantial.
So,
You know, if there's any way to cut through this, we've gone through this so much. We had a court case about it, and we lost. It's like, get it over with. Let it build it.
if you,
It's up to you. Remember, at the time this came in, there was an airport there.
yeah,
Now there's not an
now
airport.
there's nothing.
How much difference does it make?
That's true, it is decommissioned, so I mean, but if there's a substantial difference to the plan that requires an NPDES permit, I'm willing to, you know. I
So
sus-
that, yeah,
forgo it, no, I suspect that,
that's another year.
Well, you don't have any control over that part, Robert.
Yeah.
yeah.
All
Thank you.
right, I'm just stating the fact that, you know, we flogged this to death.
I don't disagree, but I'll reluctantly, you know. No, I mean, we don't technically have to take any formal action, we can just make sure. the
Well,
plan-
you don't- Yeah,
Yeah.
you don't have to take any action tonight, but I think you may want to send it to the planning commission.
Yeah.
I do have a question to that point, because this was brought to my attention and it was submitted to the township about 4 days ago. There were no funds with this. If this needs to be treated as a planning commission and there are substantial changes, do we need to send them a letter saying that this is not administratively complete then, and that they need to submit to us the funds
Yes.
before we'll consider it?
That's good to know, because that means the clock didn't start.
That's fair.
And what I can do is I can take a look. And I can try to outline for you, shoot you an email as to what the changes are, so that you can have a better understanding of what they've done.
Okay.
Yeah, that sounds fair.
John, for my sanity as well, you would be so kind, can you put together a letter of the requirements for whatever they're doing for this submission funds wise? So when I turn around and say, it's not administratively complete, we need money from you.
Yep.
I have some backup for that.
Good, I will do that.
Is Rich Williams still handling?
Yeah,
Okay, that's a step up.
Yeah, that's good. That sounds perfect. So with that, I would move that we continue the discussion on item I at our next meeting.
Second.
Motion by myself, second by Mr. Levenheim. Questions? All in favor?
Aye.
Aye. Next is the discussion on proposed resolutions and nominations report for PTAX. I would respectfully suggest that the 3 supervisors just submit their comments on the resolutions individually to Julia, so we don't have to. And another 20 minutes here, seeing if there's only 2 supervisors, because one got upset and decided to leave. I don't think there's a problem with that consensus, Robert.
No.
Okay. Motion by Mr. Levenheim. I hear a second. Well, yeah, I had a second, there's another supervisor. Any questions? All in favor?
All right,
Aye, for the board of supervisors report, I just want the record to reflect my dismay that. Evidently, there's some people here that don't wanna have civil discussions or disagreements and. I admire those that stayed, including you, Tim, until the end of this meeting. And were thoughtful and careful in discussing the things that we were meeting about today, and I look forward to a new third supervisor that is not named Barrett.
I concur, and I think there's no place here for rudeness.
Yeah, no, it's just, we got the. All right, Albert, anything else you wanna know before we pay the bills?
Pay the bills.
Okay, all right, we have general fund obligations to the tune of $114,622.66. No liquid fuels fund, but we do have escrow funds, in the amount of $1,094.41. Do I hear a motion, we pay the bills?
Motion to approve.
Amendment 11, and second. Any questions? All in favor?
Aye.
Aye. And finally, we reach public comments. Any comments?
No, I just come to make sure that if there's any agreement between you and Water Gap, we're on top of it. Cause
No,
We're
the
not-
last one was only for October, so as far as everybody's concerned, that's all done.
we're not transparent over there, so. That's why we come.
No. I appreciate your interest in local government. Okay, any other last items from anybody here?
Motion to adjourn.
Very quickly, if I may, just, in the interest of time, I will be sending an email out. The planning commission has asked for a joint session.
Have they asked for it, or we asked them for it?
They asked the board that
Or joint session?
regarding parking.
Pardon.
Yeah, so they can talk about it, like, just so you know it's on the horizon.
Yeah, no, my interest will be probably at that point to like have our meeting start at like 5 or something like that to discuss that, but we'll see what their availability is tomorrow. You can ask the Roberts, I'm the liaison. All right, anything else for you, Jim?
No, I think I've disrupted you enough tonight.
You think you disrupt, I disagree with that interpretation.
Okay, motion on the floor to adjourn.
Motion by Mr. Levenheim, I will second, all in favor? Aye. Aye. You're adjourned at 8:38.
And for the record, ours gets pretty heated too, so.